SJC-13248, Commonwealth v. David Privette.
Good morning.
Hi, Attorney Rousseve, please.
May it please the court. My name is Rousseve, and I represent David Privette. This case is an interlocutory appeal from a denial of a motion to suppress, and it primarily involves the collective knowledge doctrine. But before I get to that, I do want to first talk about how the evidence fails to establish reasonable suspicion. The question here is whether, based on a very detailed description of a black male suspect, there's reasonable suspicion to support the stop of a black man in Dorchester whose appearance varied from the description in 6 major respects: height, the color of his shirt, the type of shirt, whether it had a hood or not, the color of his pants, the presence of an undescribed red plaid backpack, and the presence of an undescribed beard. The amount of detail that this witness provided shows that the witness had ample opportunity to view the suspect and even saw the suspect from behind as he fled from the scene. Despite this, which means he would have seen any backpack worn by the suspect. Despite this ability to observe and recall all these details, many of these details, aside from race and gender, have some type of error. These 6 discrepancies are simply too great to sustain a finding of reasonable suspicion.
Can you compare this case to Commonwealth versus Evelyn as far as description, general descriptions in time and proximity analysis?
I think the major difference in Evelyn, if I remember correctly, is there was observations that were consistent with the characteristics of an armed gunman. So there was something about the defendant's behavior that indicated that he was armed. There was very close proximity to the fatal shooting, and I think there was the police were able to observe a gun-sized object in his pocket. His hand was pressed against his body. He turned away from the police, so he exhibited sort of the bleeding and that type of thing. And I think in Evelyn, it was still described as a close case. So we don't have anything like that here. We
have time and space basically match Evelyn, I think, right?
Yes, and in terms of proximity, yes. But Evelyn...
In 7 minutes versus however minutes.
Yes, I don't recall the exact time, but I know that it was close in time and temporal and geographic proximity. Yes, absolutely.
Does it matter that it was about 3 or 4 o'clock in the morning and it was raining and nobody else was around?
I think that's certainly a factor. The fact that it was raining, I think maybe less so. This is Boston. This is not San Diego. Rain is not the type of weather that would send people scurrying home. But certainly the fact that he was the only person out is relevant, but it's not dispositive. And we know that from Warren, and we know that from Martinez. Those are 2 cases where the defendant was the only person out in a deserted area, and there still was not reasonable suspicion. I think what we learned from those cases is there must be some other sort of aggravating factor or plus factor, something about the weather being extreme. Like, for instance, in McCoy, the weather there was a cold, wet, slushy night full of wind and snow. Obviously, rain does not really rise to that level. Or in the White case, there was something unusual about the area that made it very strange for pedestrians to be out. In that case, it was a deserted commercial zone at 3:30 in the morning. We don't have anything like that here. The area here is a mix of residences and public-facing buildings or businesses. Like, there's the CVS pharmacy, there's the Chinese restaurant, there's the gas station, of course. So there's nothing peculiar about the area or about the weather that would make it so strange to see a pedestrian out.
At 3 a.m.?
At 3 a.m.
Counsel, may I, before we lose all the time to reasonable suspicion in that analysis, can we talk about the collective knowledge doctrine?
Yes.
And can you please tell me the difference between, or what your understanding is of vertical collective knowledge and horizontal collective knowledge?
Thank you so much, yes. So the original form of collective knowledge is the vertical doctrine, which is essentially a direct imputation rule. So one officer has complete information. They exercise that judgment over that information and decide whether it amounts to reasonable suspicion or probable cause. In the horizontal variant...
Wait.
Sure.
So then what happens?
So then when there's, let's say there's an arrest based on an officer's order to arrest, and a second officer executes that order, when you do the analysis to see if that's justified, you look to the knowledge of the instructing officer.
Oh, so there does not have to be an authority relationship between the 2 of them?
I don't believe so. It's just, is there a directive or a request or a BOLO, for instance?
Is that stop the red car? So one police officer gets the information, says, stop the red car.
Right, right.
And
as
they
long-
stop the red car.
They stop the red car. And as long as the officer who radios, hey, stop the red car, as long as that person has reasonable suspicion, then the stop is proper. So you just substitute the information known by the directing or requesting officer for the officer who
So
executes.
in that instance, you do no aggregation at all?
Correct,
Okay,
correct.
so vertical has no aggregation.
Correct, that's absolutely right. And I
So
think
it's really not a collective knowledge.
I think it's better termed like a fellow officer rule, and that's sort of how it's originally described in some cases, and I think that makes more sense. Does that answer your question as to the?
Yeah, yes, it does, but now can you describe
Yes.
the other one?
So the difference in the horizontal doctrine is that the information is not centrally held by one person. It is scattered between different officers. So there's not one person who has sort of the totality of the information and can exercise their judgment and say, this amounts to reasonable suspicion, or this amounts to probable cause. And the problem with that becomes it totally eviscerates the deterrence rationale. If the purpose of the exclusionary rule, of course, is to deter unreasonable searches and seizures, the only way you can do that is to operate on the decision maker.
Now, I'm confused because I know we look at the totality of the circumstances, and we have cases, right, and other jurisdictions do too, where they do the aggregation. And you're saying that we need to only focus on the arresting officer or the officer who executes the search warrant or makes the stop?
The decision-making officer.
Decision-making
So whether
officer.
that is the officer who makes the request or whether that officer is the officer on scene who's making an on-the-scene decision to do the search, the only way deterrence works is to look at what is happening
Right,
within the
but
decision maker's mind.
I understand the deterrence argument in the exclusionary rule, but what I'm thinking about right now is that as we look at search and seizure analysis and doctrine, we always are looking from an objective point of view in almost every case. And so if we look at this from step back and look at it objectively, we look at all the facts and officer A, officer B, officer C, all adds up. But if we look at it, then if we take your approach, we'd have to look at the officers subjectively and say, what did this officer subjectively know, and what did that officer subjectively know, and or just what did this one officer subjectively know? We would be moving away from an objective analysis to a more subjective analysis. And I want to know what impact does that have on other avenues of search and seizure law?
I don't think that it becomes subjective. It's just that you narrow the analysis to just what is the information that decision maker has and what would an objective police officer do in that circumstance.
But you know what I'm confused about is the logic behind both vertical and horizontal is similar, isn't it?
Well, it's similar, but where horizontal diverges is that you don't have this one person making the decision, where you have a clear way to know beforehand whether the search is proper or not. When you get to the horizontal doctrine, you flip the incentives. Rather than deterring unlawful searches, you're actually, not only are you failing to deter them, you're actually creating an incentive to do questionable searches, because then an officer could hope that perhaps another colleague has more information.
How do we factor in the communication between officers? Because if the big issue is the beard, right? So
Yes.
Is your position that if Dwan had stopped this person, the other guy's name was Doherty?
Doherty is the officer who performed the stop, yes.
So suppose hypothetically Dwan had stopped him, okay?
Well,
I know you argue no reasonable suspicion.
yes.
Does the beard factor in to reasonable suspicion if Dwan had stopped him?
Only if the judge had found that Dwan had knowledge of the beard, and we're missing that key
Well,
finding
this is this is a strange record on Jones-Parnell stuff, and I read the appeals court decision, of course, because Doherty does testify to facial hair, and then he doesn't.
Right.
And then the judge makes a finding that it's ambiguous, I guess, or actually says that it wasn't before him, but finds him credible. and then finds Dwan credible, and then doesn't make a finding. So I don't know where all this Jones-Parnell stuff goes.
Right. It's a little bit complicated, but I think the key here is, our position is, it was a binding factual finding that the judge made when the judge deliberately excluded the beard from her detailed findings about the contents of the description. The judge's whole task was to decide, what did the police know, and did they know it and before the stop, and was that enough to justify the stop? And there's two reasons why we know this is a binding factual finding. One, it was forefronted by defense counsel at the hearing. At the start of his argument, he replayed that one broadcast, the first broadcast that had the initial description, and he said, hey, Doherty admitted.
And part of the CAD is the beard stuff later on.
Right, correct, right. So we have the 3:36:30 transmission, right, and then the beard comes in at like 3:38. Okay. But Doherty admits on cross that the only information he had prior to the stop was the 3:36:30. Defense counsel forefronts this at argument, and when the Commonwealth makes their argument, arguing that the beard is in play, defense counsel then stands up again and says, the beard is not in play. Doherty admitted he didn't hear that. I'd like to file a supplemental memo on this. And the judge says, no, I've got this. I have all the information I need. So we know it was forefronted by defense counsel. We know it was on the mind of the judge. And then we know it was on the mind of the judge when she wrote her findings, because she drops footnote 4, which says the original description does not have the beard.
Go back to Justice Cypher's discussion on horizontal and vertical. How does it play in that Doherty is on the same channel as Dwan and communicating with Dwan? Doherty, for whatever reason, doesn't hear the second broadcast. I guess that's your argument, and borne out by the judge's findings.
Yes.
But Dwan does. And they're communicating back and forth. It's still not okay to import the Dwan information into the Doherty stop?
Right, so I think there's a couple hurdles here. The first being that the judge never made a finding that Dwan heard that. And I think her finding about the contents of the description, which deliberately omit the beard, foreclose that type of supplementation. Putting that aside, yes, there's still another obstacle, which is that under Article 14, our position is it's impermissible to impute this knowledge that Doherty expressly disclaimed.
And what's the basis that the other states have come up with to disavow this horizontal collective knowledge doctrine? So
it boils down to deterrence. The original vertical doctrine does not do any damage to deterrence because you just substitute your analysis for the directing officer.
Does that require communication?
There needs to be communication of the request.
To stop the car.
But not the underlying details. So it needs to be stop the car, but it doesn't need to be stop the car because we did 6 controlled buys. You don't need to, and that's why it works. There's an efficiency rationale to it. It allows officers to just quickly say, stop this car without getting into all the details.
So in this case, if the people on scene had said, stop the guy who's on Clam Point or wherever the neighborhood was, it'd be okay?
Well, it would depend on what that person knew. I'm not sure who the person would be in this example.
Say it's the responding officers who go to the gas station and they interview the victim. And they say, hey, stop anybody who's in the general area. Well, I think that would be better for you? That would be better?
No, I don't think that works because you really need the combination of 2 sets of factors here for reasonable suspicion. You need knowledge of the description, right? And then you also need the on-the-scene observations of the suspect. To what extent does he match the description? To what extent is he in this area? Is he exhibiting characteristics of an armed gunman like an Evelyn? Is he, fleeing? Is he doing something that suggests that he's connected to this crime? So I think you need to have an officer on scene that can bring both of those sort of categories together.
That doesn't square with the vertical.
Right.
I don't think.
How's it more protective if in the vertical the person is just executing, as I think it was the imputed knowledge, I forgot what you called it, which is more descriptive, the fellow officer rule, right? How is that more protective?
Well, it would be more protective because the motion to suppress would have been granted in this case, because whoever gave that directive didn't have reasonable suspicion.
Okay. I have one minor hypothetical, if you'll indulge me for a minute, and that would be, suppose you have one very experienced officer working with a new trainee, and they both are working on the same case, but only the experienced one really knows all of the facts and knows all of the details regarding probable cause or reasonable suspicion. But before he gets a chance to tell it to the new trainee, the trainee encounters the guy and arrests him. Is that not right? Would that be totally suppressed?
It would, because again, under the vertical doctrine, which is what we're advocating for, and I think what is required under Article 14 to effectuate deterrence, you need to look at the decision maker's information. And if that decision to stop was made without reasonable suspicion at that time, then it was unlawful, and that's something we need to deter. What we want to do is encourage officers to communicate with each other. I think the cost of exchanging that information between an experienced officer and the trainee is very minimal, but the benefits are huge. So I think that's what we want to encourage.
Has this court ever endorsed the horizontal collective knowledge doctrine?
So this court has never endorsed it by name, but there are certainly cases like Roland R., for example, where this court has employed it without naming it as such.
But I'm sorry.
So we've said that's okay without saying this is called the horizontal collective
Right. This
knowledge.
court has imputed the like in Roland R., it was a young man who fled from a courthouse screening. Officers were chasing him. Another officer joined in the chase without having any idea what the purpose of the chase was, and eventually stopped him. So under those circumstances, this court said that was permissible, and it's our position that under Article 14, that is not permissible.
So you're saying that would have to be, we would have to overturn that?
I'm asking for a rule change.
Okay.
Yes, that's correct.
And your argument is that here, horizontal collective knowledge was in play, and that's the reason why this is not okay.
Correct, yes.
Because isn't it, I mean, the appeals court is the one that raised it in the first instance.
That's correct. It was not raised at the trial court level. It was raised by the appeals court, and there was supplemental briefing on it. And because the appeals court is combining information known by Doherty, information allegedly known by Dwan, which we, again, do not concede that that was found by the judge or proper to use, but because you're talking about combining the knowledge of two different officers, that results in a horizontal application.
Yes, but below, I mean, in the original decision, that's not what the trial court, I mean, what the motion judge relied on at all.
That's correct.
Okay.
That's correct.
So what if we just went back and looked at what the motion judge relied on?
Then there's not reasonable suspicion.
Based on what you said at the very beginning.
Exactly, exactly.
Because no beard.
Correct, correct.
But if there was a beard,
You still think you win?
Right, because even if you can't supplement because it wasn't found by the judge, and the judge's findings foreclose this because she deliberately omitted it. Even if you can supplement, you can't impute without violating
understood
Article
you
14.
say no beard, but if there is a beard, going back to Justice Gaziano's question about if Dwan had stopped him, if there was a beard, what do you say then?
I think there's still a lot of very troubling discrepancies in the description.
But it's
and
harder for you.
I'm sorry?
But it's harder for you.
It's certainly a harder case, absolutely, absolutely. But again, without any behavior by the defendant that suggests a connection with the crime, I would submit there's still not reasonable suspicion.
Can I ask you one final thing?
Yes,
Excuse me.
please.
And that is the Commonwealth versus Baloo, 350 Mass, 751, 1966. Are you familiar with that one?
I'm not, I apologize.
All right, that's a 1966 case that predates the U.S. Supreme Court on Whitley, and they held that it was a captain and it was a detective and it was a pat frisk, and the SJC said there's no occasion to even rely on the elementary rule of composite knowledge of the police officers, where the knowledge of one may be attributed to the knowledge of all. And they cited a New Jersey case. Why isn't that isn't that a good enough rationale? We've got that in Baloo, you're saying there's no rationale expressed by the SJC, but I think there was, and then they rely on the New Jersey case for further explanation. So I'm not sure that it's true that we haven't, or not true, but that I think you can say we certainly have addressed this in the past.
I think it certainly has been applied as a broad horizontal version of the doctrine in the past. I don't think that this court has contended with whether that is permissible under Article 14 because of the damage that that doctrine does to the deterrence rationale, and the fact that it creates a perverse incentive for officers to search without knowing ahead of time whether there's reasonable suspicion. So that is what I'm asking the court to consider, and I would ask the court, if there are no other questions.
I actually
yes.
do have a question.
Please.
So going back to the common knowledge horizontally applied, what is the, and I know this is not your position, but what is the rationale articulated by the other jurisdictions for permitting horizontal common knowledge?
Well, to the extent that it is justified, and often it is not justified, it's just kind of taken on faith that you can aggregate information. But to the extent it's justified on the basis that when officers are working closely together, you can consider them essentially a single organism. And so the knowledge of one belongs to all. And again, the problem that I have with that is that eviscerates the deterrent rationale of the exclusionary rule, so it's not compatible.
How would it eviscerate the deterrence rationale, though? Because the police officer may very well think he has enough and just doesn't.
That's possible, but the exclusionary rule is all about setting the incentives, right? The incentive is do not perform unreasonable searches and seizures, because if you do, it's going to be suppressed. If you employ the horizontal rule, you're flipping the incentive and you're actually encouraging officers, go ahead, make that questionable search, because maybe somebody else down the line has more information that can justify it after the fact. It's a way of potentially laundering probable cause or reasonable suspicion when it wasn't.
Do you have cases that illustrate that?
I would cite to the Massenburg case. That's the case from the Fourth Circuit. The Fourth Circuit is one of the three circuits that find, even under the Fourth Amendment, that the horizontal version of the doctrine.
The First Circuit says it's okay.
That's correct. Yes, the First Circuit says it's okay.
Keith, with your indulgence, can I just ask one sure. Maybe last question, at least for me?
Yes.
If you could help me out on the deterrence, I'm still trying to get my arms around this. The deterrent value, I assume, as you argue, is we look to see what Doherty did, because we want to look what was in his mind, and we don't want to post hoc say, what did Dwan know, what did Smith know, what did Jones know? And I get that for the deterrence value. But how is that different from the vertical deterrence value, where I'm on patrol, supervisor says, stop that red Audi, and I stop the red Audi. I don't know nothing about it.
Right.
I have no information whatsoever, and I'm just following orders.
Right.
How is that better for deterrence than I know some of it?
Right. So I think the difference there is that, as Whiteley says, officers are entitled to rely on the communications from other officers, for the strength of those communications. So if you're an officer and you receive this information, you are entitled to assume the officer giving me this instruction has full information, and I trust their judgment so I can go execute it. And if that turns out to be wrong, there's a remedy, because we look at what the instructing officer knew. And if that instructing officer was incorrect, then the evidence gets suppressed. So there are guardrails there that just aren't present.
Yeah, so it's, I get it. So we're only looking at one source, and,
Exactly.
we can use our exclusionary rule to say whether it's sufficient or not, as
Right.
opposed to combining all these sources.
That's exactly right. I think that's the central issue. Is there one person who has the information to make the call that allows the court to analyze that information to see if it's sufficient, or is it dispersed among many people so nobody knows beforehand whether there's sufficient
But
information?
in this case, had Dwan been in communication with Doherty, and Doherty had known about the beard, it's a different story.
It's a different story.
That would be a different collective knowledge.
Exactly. That's right.
Okay.
If there are no further questions.
Oh, I could keep going, but I know we have
I'd
time
be
limits.
happy to stay here as long as you want to hear from me.
Yeah, no,
We'll
we
keep
got the
moving.
gist. We got the gist.
I would ask the court to reverse the denial of the motion to suppress, and I would ask the court to restore the collective knowledge doctrine to its original form, which is the only form that comports with Article 14. Thank you very much for your time.
Thank you.
Thank you. Okay, Attorney Sherman.
Good morning. And may it please the court, Kathryn Sherman on behalf of the Commonwealth, asking this court to affirm the motion judge's ruling.
Can you say whether or not you think it was necessary to go to the horizontal collective knowledge doctrine in order for the Commonwealth to win this?
No. The beard is superfluous to the finding of reasonable suspicion. This Officer Doherty had reasonable suspicion to stop this defendant regardless of whether or not he knew the beard. And that's because of the geographic and temporal proximity, the defendant's sole presence at 3:34 in the morning in the rain. He was the only person present in commercial or residential areas. The fact that he met the general description of the armed robber, and the fact that the police were investigating
Don't you have
an armed robber.
don't you have a cheek problem with the general description?
We do not have a cheek problem with the description. The defendant matches the description of the robber in many more significant ways than the description given in cheek.
I thought it was just gender and race.
Gender, race, build, medium, height, basically average range, age, being late 20s versus early 30s.
I thought Cheek was young black man in a down jacket, whatever, the snorkel jacket, whatever it was.
Yes.
During the day.
It was not, Cheek was not during the day necessarily, it was at night.
I meant during the day,
but-
the style of jacket,
Yes,
whatever
yes.
it was. I think it was a snorkel
It was a
jacket.
common jacket, but Cheek specifically says the officers possessed no additional physical description of the suspect that would have distinguished him from any other black male in the area, such as height, weight, facial hair, unique markings on his face or clothes, or other identifying characteristics. And what the, not to put words into the court's mouth, but the message seems to be that that reasonable suspicion needs to be based on something that would eliminate other people and is not going to cast a wide net of people that are properly in their neighborhood wearing the most common attire in a Boston winter. Here, the circumstances are quite different, both because of the area being searched, the time, the day, the fact that he is the only person present. And Judge Cypher, I apologize, or do you have a question?
No, I was just thinking, go ahead.
But isn't the beard a distinguishing factor? Meaning that if the first officer is looking for somebody who meets this description, but he's not aware of the beard, and then someone shows up with this long beard, doesn't that take us into a different realm?
No, I argue that it wouldn't. It would not eliminate or in any way mitigate the other many ways in which the defendant matches the description of the robber.
It just seems like the most distinguishing factor and that seems to be why the appeals court gravitates towards it.
I agree with the characterization of why the appeals court inserted that issue into the facts here. However, the appeals court also specifically says that if Doherty had known of the beard, that would have further supplemented his reasonable suspicion. I'd suggest that the collective knowledge doctrine and the exploration of this beard issue is superfluous, both to the appeals court's finding of reasonable suspicion and this court's reevaluation.
How could it be superfluous if it's such a distinguishing characteristic? That's what I find troublesome. I mean, whether this met reasonable suspicion or not, close, but if the first officer is not looking for someone with a beard and someone shows up with a long beard, that seems to be an important
Justice
distinction.
Kafker, I think that she's responding to my initial question, which is, does she have to have the beard to win?
No, I get that, but I just look at this as a different issue. If Doherty thinks the guy doesn't have a beard, and he stopped him, but again, I posed the question.
And putting it into further greater context with the stop, as the motion judge mentions in her finding of facts, this is a stop in the dark, in a dark area, and that Doherty is approaching the defendant saying he matches the description, including that he matches the description of the facial hair, but that's a side note related to his testimony and whether or not he contradicts himself. but he is approaching this defendant saying that he matches the description in most meaningful ways, should this court find that he was not aware of the beard, which there is
Counsel, can I
evidence that
ask
he
you,
was.
so the defendant is within, is it 700 feet of the armed robbery?
It would be 700 feet if he took the shortcut that was
So 700
explained.
feet of the armed robbery through the shortcut in the direction of the fleeing suspect, generally matching the description cheek,
Yes.
footnote to cheek, and also within 7 minutes.
That's correct.
Right,
7
and
minutes of the
that's
robbery.
what you're saying is enough for reasonable suspicion.
That's correct.
Okay. Can I ask you to address the collective knowledge doctrine? What would be the rationale for allowing a horizontal collective knowledge doctrine in Massachusetts under Article 14, given that, as I understand, the rationale for the vertical collective knowledge doctrine is to allow efficient law enforcement? How does that further the underlying purposes of collective knowledge?
I will answer your question in 2 parts. First, beginning with the fact, as I think the court's questions have really probed at, the horizontal and vertical dichotomy is inapplicable to Massachusetts law in terms of the application of the collective knowledge doctrine in this court, when it is rarely used, does work within its own limits. The pattern over the last 60 years within this court is that collective knowledge doctrine is imputed between officers when they're involved in a cooperative effort and there is a form of communication between the officers.
But
and
the officer who's arresting in the horizontal case
Yes.
actually objectively does not have reasonable suspicion. He's not just relying on the reasonable suspicion of another officer. In fact, he objectively does not have reasonable suspicion, and ex post, we supply this organic or organism-based knowledge among disparate officers who may be working together but have never communicated to any single source that there is enough reasonable suspicion, which I think is your opposing counsel's argument, is that it creates a disincentive. It creates actually an incentive to arrest without reasonable suspicion on the off chance that someone in the department has the other aspects of it. In fact, not just someone, but maybe 3 different officers.
And to respond to that, but back to your original question at the same time, the efficiency or the efficacy of the law enforcement rationale that is invoked behind the collective knowledge doctrine, I think this case is really a perfect example of that. That Doherty and Dewan are arriving simultaneously to stop this defendant. They are approaching from 2 different sides. And should this court find that Dewan was the only officer who knew of the beard, had he stopped the defendant first, had he been the one to take 1 step further, quicker than Doherty, then he would have had reasonable suspicion without imputed knowledge. Doherty did the exact same thing, which of course we believe he had reasonable suspicion, but that is the balance between
So let's
balance
get
coming
away
back to
from the
the-
facts of this
Sure.
case. Let's say we have a cheek situation, right?
Yes.
Black man in a goose down jacket, 3/4 length, right? And
Yes.
it's about midnight. And there's a bunch of people who fit that description. I arrest the defendant, right? Because I'm an officer. And Cheek says that's not enough for reasonable suspicion. It turns out that my fellow officer also knew he was wearing a backpack and had a beard. Then that gets you over the hump?
It would only be imputed through collective knowledge through if those officers had been engaged in a cooperative effort, which requires more than just being officers in the same force at the same time.
But we're all hearing the same call.
And there needs to be a means of communication between the parties.
But we
isn't
don't
that
have
what
that
we
here.
have here? That's the problem that I'm having here, is that we keep overlaying that somehow this set of facts was that this was like a coordinated kind of investigation. It really wasn't, right? I mean, Dwan and Daugherty just kind of happened to be on, one was on a detail and one just kind of happened to hear the broadcast and go where the puck was going. But the issue that I'm having with the argument that the Commonwealth, and I can't really glean whether you're saying that this was truly a horizontal collective case or not, but this typical case that we see is the cases that Attorney Rousseve and I dealt with all the time, right? You have the street-level drug buy, you have the car go away, and you have somebody follow the car who they think is the buyer, and the police stop the seller, and or pardon me, the other way, and the buyer says, hey, I bought some drugs from the person up the street. And now they radio and say, get the person up the street. Because now you've got a true collective kind of vertical knowledge and say one person has it and says, hey, go and pull that car over. That's not what we have here, though. So help me understand that. Like, if you use Justice Wendlandt's example, no one knows who this person is other than he happens to be on the street in the middle of the night in the rain. And Daugherty arrests him. He doesn't have any of the additional, more specific characteristics. He just arrests him, and then we get to say that the Commonwealth gets to backfill it from the other folks who weren't all working together in a coordinated effort of some sort on some drug activity or some other alleged unlawful activity. They just happened to be responding to a call. How does that square?
The collective knowledge doctrine would not be able to be applied in a hypothetical where the officers are not working together in a coordinated fashion. And I know I was asked to stay away from the facts of this case, but if I may, there actually isn't evidence in the record that they were cooperating together. Daugherty testifies that he knew where Dwan was coming from. He knew that Dwan hadn't found anybody on the street, and the path that other officers were taking informed his choice to go to this other neighborhood, knowing that they weren't being searched for there. So there is evidence of the cooperative nature. They're working on the same investigation.
But they weren't communicating. I thought you said they have to be able to communicate.
They were both on Channel 6.
Okay, so you're saying just generally, if everybody's on the same thing, if everybody's hearing the same thing,
No, you're right, Your Honor. I shouldn't have interrupted your question.
No, I'm just asking, how were Dwan and Daugherty in communication with each other?
They did not have direct communication with each other. And
I thought that's how you said it would.
Right.
It could work.
Yes, it could work. And the reason that I'm phrasing it that way is because that is the pattern among the cases from this court.
Which leads to the Chief's question to opposing counsel. We have recognized horizontal in the form that counsel has asked, and that's what we have to take a look at, because that would be the change, would to see whether we continue to have horizontal collective knowledge, correct?
Yes, that's correct. This court has recognized horizontal in very rare instances. And I think a good example of when this court has refused to apply horizontal collective knowledge doctrine would be a good distinction to make to the circumstances that defense counsel says may occur. It's an older case, but Hawkins from 72, 361 Mass 384. In that case, collective knowledge did not apply when officers executing a drug search warrant came across evidence of they were stolen bonds, some sort of paper document in a paper envelope. They saw that in the course of their search warrant execution. They did not know before the search warrant was executed. They certainly weren't looking for bonds, but others in their department were investigating that same crime, and they found that out after they had found the bonds.
Can I ask you another hypothetical?
Yes.
Say there's a third officer who's listening to the broadcast but never shows up. but actually heard the second broadcast, would we impute that person's knowledge?
And if I may just repeat it to make sure I heard it, a third officer who had heard all of the broadcasts but did not appear on scene.
But never came to the scene. Say Dewan didn't hear the second broadcast, and neither did Doherty. But a third officer who was listening and maybe even in the vicinity, but he never shows up. Would we impute that knowledge?
No, I don't believe that would qualify as being involved in the cooperative effort.
Even if he were someone looking for the guy, never came around once he heard they'd arrested the person.
I mean, he's on Channel 6.
No, I do not believe that would qualify as a cooperative effort.
So they have to show up at the scene as well as be involved in a cooperative effort. Mm-hmm.
As a general answer, I'd say yes, there needs to be more active engagement than just being on the channel.
Okay.
So what are you saying? You said that we use it here in Massachusetts. We use it in a very limited fashion. What are the contours of the limitations? What is it that you're saying we should continue to do?
That information, that officers are involved in a cooperative effort together as the first limitation, and that the information is communicated to those officers who are involved in the cooperative effort.
If we did that, we wouldn't have it in Roland R, would we?
In Roland R, the description of the person being chased was communicated.
No.
And
if you just take the basic facts of Roland and you have a group of officers who don't hear any broadcast whatsoever, but they see another group of officers run out of a building chasing someone, and it's pretty clear that you can infer that they want to stop that person. This other group that has no idea why they're chasing them, just sees that they're chasing someone. So they just infer, this is somebody I need to help them stop. Wouldn't that cut against you if that were the case?
And I apologize. I was answering the question, I suppose, more in the hypothetical horizontal scenario. What has been categorized as the vertical, the basic, more of a command situation, would not require those limitations. These are the limitations that I'm suggesting are what already exist in a more peer-to-peer collective knowledge situation versus the go get him type of collective knowledge.
So Roland R is a go get him.
Yes.
So that's a vertical case.
Yes.
Okay.
Okay, I thought we said that there.
I thought we said Roland R was a horizontal case, but.
No, well, that's what.
Right.
That's. I guess the question is, has this court ever endorsed horizontal?
Yes, that would be, the facts are not overly fleshed out in this case. It's again, an older one. Chaisson, Chaisson, it's from 1971, but there it's officers involved in a stakeout that are all in radio communication and one another's observations are imputed to one another. Similarly, in
Don't we have a recent
Montoya.
case, Commonwealth versus Mendez, 476 Mass 512, where we cite Quinn approvingly, and Quinn's the appeals court case that expressly adopts horizontal?
Yes, that's correct. That was also a chase situation where the reasonable suspicion about the shooting is imputed among the officers involved in the chase.
And in that case, no one officer had the reasonable suspicion. It was you needed all of the officers, disparate, although collaborative, knowledge to establish reasonable suspicion.
I believe it was aggregated among officers in terms of the officer who initiated the stop but did not have, or the details
we
of the
can
facts
check.
escape me, but I believe there was aggregation required in that case.
Counsel, the First Circuit had a case from 2002, U.S. v. Cook. I don't know if you're familiar with that one because I know it wasn't, this wasn't a primary issue below, but they upheld the collective knowledge doctrine, and they had specifically addressed this deterrence factor and said that they did not think that, well, because investigative stops are usually dynamic, in a dynamic environment with a potential for violence, joint stops, the officers rarely have an opportunity to confer during the course of the stop. And to base the legitimacy of the stop solely on what the officer who first makes contact with the suspect knows, rather than on the collective knowledge doctrine, they didn't think that made practical sense. It's not common sense. It's not what happens out, because police, as we all know from television, they look at each other and they point, right? So they also said, though, that, and I want to just address the deterrence issue and know what you think about the exclusionary rules application in this instance. They said that they did not think that recognizing a more limited principle that took only into account the knowledge of the officers present at the scene and directly involved is unlikely to, they think that's unlikely to encourage illegal police activity. So they've specifically addressed the deterrence factor, and they don't see that this is a problem that if we keep the collective knowledge doctrine, we're going to have all this rampant abuse. What's your experience with that in the research that you've done on our Massachusetts cases? Do we have anything addressing that?
I didn't find anything directly addressing that, but I do think the application is consistent with that in terms of the collective knowledge doctrine. When it is rarely invoked, it is invoked in rapidly unfolding situations in which there is an immediate danger or an investigation of something that does pose an immediate public safety risk. And the pattern of that seems to be consistent with that case in terms of there not being a long, detailed investigation where communication is easy and ought to be a default, or it's always meant to be a default, but where communication is more naturally occurring than in these rapidly unfolding situations where, such as here, 7 minutes are passing between an armed robbery and someone being found on the street who may pose a danger to the public. And the officers who are engaged in that investigation together, and I would generalize to say that when knowledge is imputed by this court, it is in what we are characterizing as a horizontal situation. It is usually details of a small nature, not necessarily aggregating among many, many officers, small details that must add together. It's adding to the acting officer, the decision maker, an additional detail that makes clear that there was reasonable suspicion or probable cause at the time of the decision.